Good evening and welcome to Wednesday Night Live from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you everyone for being here tonight. We have a ton of people already in the chat, some very familiar names I've seen before, Farm Girl and Queen Olive and Krista, but a lot of new names, and I am smart enough and humble enough to realize that has nothing to do with me, that it's not like the popularity of this channel has grown overnight, but I know a lot of you are here because of the special guest that we have, and that is Scott from Recovery Addict. We're going to be bringing him on soon. He's been gracious enough to discuss some of the cases he's been following closely with us this evening, so we're very tickled for that. So thank you. Welcome to all the new people who are here. So glad to have you. I see a bunch of RA sent me in the chat already, so we're very happy to have you. Welcome, welcome, welcome. RA crew here and running deep. So thank you guys very much. This is what we're going to do tonight. Like I said, we're going to bring Scott out. We're going to talk about two cases he's been following closely. That is Collin Griffith. I'm going to go ahead and not bury the lead, but let you know this is the young man who was stood trial for killing his mother by stabbing. He had shot and killed his father 18 months prior, and charges were never brought on that because of the same argument of self-defense, which is what he argued in this case. And earlier today, he was found not guilty. So we will get Scott's reaction to that. I think you can already tell what my reaction to all of that is. And then another case that is beginning, day one started today, is a really awful, heartbreaking case regarding a woman by the name of a young lady, 18 years old when she was arrested, by the name of Megan Boswell, accused of murdering her toddler daughter. These ones always get me right in the heart. Both cases that Scott is been following closely. The Recovery Addict Army has been following closely. So we'll get into all of that. And then we always do a poll. So if we run out of time at the end, we don't have time to talk about everything. Here's the three cases that are your options. We'll put a poll up. Tell us what you want to hear about most, and we will try to get to it. Those are David Pearce. There was a verdict also in that case. He's the man accused of dumping two beautiful young women off at different hospitals here in Los Angeles, both of whom were overdosed on fentanyl. Lori Vallow is back in the news because she's got some things to say about Court TV, which I find to be hilarious and worth chatting about. And then finally, Jennifer Crumbley. She's the mother of Ethan Crumbley, who was convicted of voluntary manslaughter for her involvement in her son's commission of a mass shooting in Oxford High School. And the judge feels she has some strong arguments for a new trial. And the judge hasn't made a decision, but we'll get into what those arguments are. Let's do some obeisance to the algorithm gods. Hit the like button if you haven't already. Please subscribe to this channel for all the new folks here. We would love to have you, but I'm not going to waste any more of your time listening to me. You're all here for this gentleman. Hello, my friend. How are you?
Josh, it's great to be here. I think that was like a very kind introduction, more than I deserve, but wonderful to be here tonight.
Please. I'm so thrilled to have you on because you are one of the people who follow these cases so closely, but you do it in a way that involves so much engagement with your subscribers that I really appreciate. How not only do you have a chat going, which many people do, but you have your burner phone call-in number that people can call to, and your ability to kind of courtroom hop when you guys are on a break, and you just really bring something, I think, very special to the idea of live streaming trials that I haven't seen. A lot of people are live streaming trials, but you do it in a very unique way. So I'm very happy to have you here.
Oh, well, thank you. I've found that it's a lot better to watch trial with friends than by yourself, and I found a great community that's I can never leave for that reason.
I think that's what it is you've turned a bunch of people who only know each other by their name in little emoticon or whatever you call it, avatar, and made them friends the way that you've put it all together. So I kudos to you. And if you guys love Scott and can't get enough of Scott, I think we've already announced this. And if we haven't, I'm just going to go ahead and announce it now. But coming out this Monday, Scott and I sat down for an interview. So we did one of our Courtroom Confidential conversations with Scott, and I really liked it. We had a good chat about where you came from and everything that led to this, and the incredible journey that I think there was a guiding hand over you, leading you to where you're at today. So if you guys are interested in hearing that backstory, it'll be on our channel next Monday. And I'm hoping I can bug you to maybe even be in the chat for that.
I'd love to. That'd be awesome.
Okay, fantastic. All right. So we put up the poll, but let's get into Collin Griffith. First of all, tell us, I did a very short and probably did not do justice to the facts of the case, but give us, like, in a nutshell, what was going on in this case.
Oh man, you nailed it. The peak points is we have a son accused of murdering his mom in a brutal, knife involved way. But when we get into the facts of the case, yes, it's true. He did 19 months prior to this. He did shoot and kill his dad. The jury didn't hear that. The jury wasn't told that. They knew that he had shot and killed someone and that no charges were brought, but they didn't know it was his dad. But what we saw through the development of the case was sadly a family that seems to have been dysfunctional at many levels, possibly for generations. And then this end result that came up where, we have a trial. We have someone charged with murder, and it was heart-wrenching to see, because it seems like it's one of those, both cases we're talking about tonight are things that it shouldn't have gotten there. It shouldn't have gone that far.
Yeah. Well, I mean, I suppose you could make that argument in any kind of murder case, but certainly things when you're talking about family members and amongst people who should be caring and loving for each other, you're absolutely right. You would think that there are plenty of off-ramps and ways to avoid this kind of violence. But you identified, which for me as an attorney was one of the more interesting points about this whole case, and that was the judge decided to let in the fact that he had actually shot and killed. It's like undisputed he shot and killed his father.
Yeah.
So it wasn't like an allegation. It's not like he's been charged with something. It's undisputed he shot and killed his father. So they allowed that to come in, not as a prior conviction, just as a prior thing that had occurred in his life, but did not disclose that it was his father or who that person's name was. And I'm curious, do you think that was the right thing? And can you tell us a little bit more about why the judge made that decision?
In hindsight, I think it was the right thing.
Okay.
I will tell you that watching this court, it looks like we were tiptoeing around the elephant in the room, trying not to say the magic word of dad. But we approached it from every angle we possibly could without crossing that line. And I think the jury could probably put it together. But looking at our community that watched this and then comparing that to the result we saw with the jury, I think the judge was right. We knew that he had shot and killed his dad, arguably in self-defense, and it was prejudicial. It influenced our decision, and the jury did not know that, and they came to a different decision. I said throughout this trial that I wasn't sure the state could get past that burden of beyond reasonable doubt, because sadly, his mom did have some issues. She had a past that was troubled. She had, even when it involves her son, when it involved Collin's dad. There have been attacks. There had been, the police involvement in family life was not something that was new to this case at this time. And I think the state just couldn't get past that point that it's, reasonable to think that it might have been self-defense, or at least that could have occurred. So,
it's I've gone back and forth. This case really got to me, and I really went back and forth about this decision by the judge, because I understand. Obviously, the what we're doing here is we're trying to weigh the ideas that a judge is doing in many decisions between prejudicial versus probative value. All evidence is going to have some prejudicial element to it, but is it so prejudicial that it outweighs the probative? In other words, is it helping the jury push them forward towards a end goal, or is it just going to influence them to make a decision outside of the evidence? Is really what it comes down to. And here's, first of all, the mere fact that someone had committed a justified murder, even if you want to call it that, a murder with self-defense playing an element in it in the past, does not mean that that person can never be involved in that situation again, right? Highly unlikely, but not impossible. So I can understand where the judge would want to avoid the idea with jurors of they're going to hear that he did this before and just go, okay, well then, you know, what are the chances? Of course he did this here, because you only get one crack at a self-defense in your life. Do you see where I'm going?
Yeah. I've been putting some more thought into it, because I was floored, even though I thought that I felt in my you know, personally that he was guilty. I was floored when it came back not guilty across the board. I thought possibly the jury, when they heard the story of his mom interacting with his dad and the trouble they had, because there was a time when she used the car and pinned him against the house. There was a time she attacked him with a corkscrew. These were times that the kids were present, and the kids were like banging on the hood of the car, trying to get mom to back up to let dad off the house. These are troubling events. And it's possible the jury could have concluded, you know, maybe mom and dad were both bad. Maybe these were both self-defense. If, you know, he wasn't charged last time, is it possible this is just an extension of that? And there was a lot of, you know, chat likes to call it victim blaming, because it seems like the one person who isn't there to defend themselves was the one who was dragged through the mud in the trial. But there were issues that under Florida law, can be brought up and can be considered in the case to see if this the victim in this case had a propensity for being truthful, for you know prior acts and things like that. And the jury listened and got us to a not guilty.
All excellent points. And again, I'm only pausing because I feel like my brain is, you know, turning rocks inside my head to just try to figure this out. But here's the other part of it, though. By telling the jurors, that he had been involved in this before and only giving them part of the story, from a prosecutor's perspective, I think I would have been arguing, listen, Your Honor, the only reason this is probative is to show the animosity this young man had towards his parents in particular. This is not, if this were like an unrelated person, you could almost understand why the identity of that person would not be important. But it seems to me, and I'm putting on my prosecutor hat here, the identity becomes squarely important for them to understand the animosity that this young man carried towards authority figures in his life, and in particular his own parents. And that's why his claims of self-defense cannot be believed here. And so it's like, I almost wonder if I would have felt better if he kept it out altogether, or allowed it in, but allowed them to know it was his father. Do you see where I'm going, or am I overthinking this?
I see that. Hindsight being 2020, where you think it might have been different to prosecute this differently, might have gotten a different outcome. But I don't know. I feel like I just watched the Casey Anthony trial. That's how I feel inside. Like I feel like it was wrong. At the same time, I respect the process and the decision. And I don't know. It's just it was a broken situation from the get-go.
Yeah.
And I felt bad in a way for Collin, for how he grew up. We heard ring camera footage of his mom and the interaction and how that went. His mom was a young mom. She got pregnant with her first child at age 13. That was Collin's older brother. So there was all sorts of problems from the get-go. And so he was playing with a shorthand to begin with. But at the same time, I think he did come across as someone who could reasonably think something through, knew what was right and what was wrong, and should be accountable for his actions if he did something wrong. So I'm still trying to balance it all in my head and juggle the result.
I've got a question for you, and maybe I doubt we have an answer just yet because it happened today, but I'm curious if we've heard from any of the jurors now that they're out of being sequestered, and now that they know the identity of that prior victim has been revealed to them. I can't imagine them being able to pick their jaws up off the floor. Like, do you think that if I were one of those jurors, I'd be astounded to learn that afterwards.
Yeah. I'm a curious person. If I was a juror, which I've never been, I would want to know, what didn't I know? I want to rewatch the case and see what everyone else saw.
First thing I'm doing.
But the judge was so careful. He didn't even have them speak, like the jury foreperson. He didn't even reveal the gender, like the man or woman. There was no speaking. All the communications he had during the verdict was by raising of hand. So he's been very protective. If the jury wants to say secret, they pretty much can. And I'm hoping they talk, because I'm curious.
Yeah,
I wish I could see into
almost any case. I'm more curious to hear their thoughts, just because there was such a huge thing that was kept from them, and there are legal reasons for this. But yeah, I mean, we get there's a lot of talk that we have in different cases about, like, how much should jurors know, and should we allow jurors to ask questions in the middle of trials and things like that. And I think this is a great case to demonstrate how the universe that the jurors know is very carefully tailored. And there's a bunch of reasons for that, and those reasons are all very good reasons, but what they know is very different than what many of us outside of that courtroom know, and that's why sometimes we become frustrated and shocked by their decisions.
Yeah, those instructions the judge reads at the beginning of trial, it probably goes over the jury's head, right? I'm going to be the judge of the law, whether or not things come in or not. And you be the judge of the facts. That sounds like nothing until the jury starts deliberating, and then after the court case, I imagine the jurors go back through the instructions and say, "Well, that's what it meant." I do feel a little bit, because we've watched many court cases. This particular one, in Collin's case, the judge was phenomenal. Even in reading the instructions to the jury, he was very slow and deliberate and clear and easy to understand. But many times I think we've picked these people off the street who, some of them have never even watched a trial before, might not have any interest in it. And we've sort of said, okay, you're in charge, do the verdict thing. And I wonder, we watched a little case just that happened yesterday, a tiny trial up in Washington, where the jury came back with a verdict that wasn't unanimous. They don't know what they don't know.
Right.
So it's I imagine after the fact, the curious jurors will watch this, and I hope they come out and speak and share their opinion. But at the same time, I respect if they don't. I'd be the first to watch.
What were your thoughts watching it? And not in, I'm more curious, putting aside the issue with the father, just the facts of this case, because she had a stab wound to her neck, right? Yeah. And at first he's claiming he had some different stories, right? Didn't he first claim she fell on it during an altercation? Then he's claiming that she came after him or something like that. And then finally they landed on this self-defense is what they argued at trial, right? Did it seem to make sense and comport with the evidence to you?
They argued all three. Like, in closing, they argued both, like, accident and self-defense at the same time, which I don't know how you can do, because Collin didn't have to take the stand because there was some evidence that would indicate this might have been self-defense. So he didn't have to be the one on the stand to testify. So we never got that story, and we just have the blood, the crime scene, and what happened outside the house with hair pulling and a fight that was observed by two neighbors. The interesting part to this was the crime of kidnapping that was charged. Was observed by two people who saw it differently. But if the jury had come to the conclusion that kidnapping had occurred when he allegedly pulled his mom in by the hair into the house, which I thought was like a done deal. It's like, the neighbor heard, "Stop, Collin, you're hurting me. Watch, there's here, earpods that have dropped out on the floor." Clearly there was a struggle outside the house, inside the house. And if they had found that there was kidnapping, it would have taken self-defense off the table, because you can't instigate and then claim self-defense.
Wow, really interesting point. Interesting point.
They could have gone with a lesser included. They could have gone with second degree or manslaughter, but they couldn't go with self-defense if they found the kidnapping. But they found no on the kidnapping, and then they went with self-defense, or with the not proven idea that beyond reasonable doubt, the state hasn't proven it. I really want to hope. I hope the jury will tell us what the decision was. Like, did they feel it was actually self-defense? Did they feel it was an accident, or did they just feel that they have reasonable doubt?
I feel like, hearing you talk it through, I wonder if it wasn't the last one, that they just, like you said, this was such a troubled family. There was history of violence from both of them. They sounded like they were a mess of a family, a lot of violence, a lot of dysfunction. And I wonder if the jury just felt, end of the day, I don't know who was going after who here, because they had both gone after each other so much. And they just felt like they couldn't, beyond a reasonable doubt, believe anything that the prosecution was trying to prove, because that is such a really good point that you make, that if you cannot create the situation that you then claim self-defense for. So had he actually kidnapped her, even if that led to her attacking him, he can't then claim self-defense because he created the situation. Wow. Yeah. Very interesting. There's still, though, because the prior case with his father, you said it was 19 months prior, which by the way, also mind-blowing how it's, not even 2 years have passed since he's now taken the lives of both of his parents, but
speedy
19
trial.
months, pardon me?
It was a speedy trial. So,
yeah.
Very quick.
19 months prior, he was, I'm not sure if he was actually arrested or indicted or what, but eventually prosecutors said that they could not disprove his assertion of self-defense in that case. That case was a shooting case.
Arrested, not charged.
Arrested, not charged. So this is my point. Because he was arrested and not charged, jeopardy has not attached. So he's still wide open. No statute of limitations problem. It's a murder. They could bring charges on that case, that prior case with his father. And I'm wondering, have you heard any chatter, or what are your thoughts on prosecutors being like, okay, dude, it was one thing when we couldn't prove it. Then you killed your mom, and now we feel like you got away with it. And we're going to take a real hard look at this case once again. And we might reconsider our dismissal of this and go after you. What are your thoughts on that?
Some of the larger media outlets that were covering this trial did release information that Oklahoma has reopened the investigation into the cause of death for his dad, which is the first step towards looking to see if they want to press charges. I think they did that because during this case there was at least an allegation by his mom, and this was on a Ring camera recording, a video record, an audio recording, where his mom said that she had Ring camera footage of him basically confessing that it wasn't self-defense in his dad's case, and that she was going to release that to X number of people at a certain time. She never did. And we haven't heard or seen it. If those exist, then clearly Oklahoma is going to look at that and say, okay, now we have a case. Now we have a confession by the defendant, and we would see charges there. But if they didn't exist, which is possible because sadly his mom did tell a lot of untruths, then I think Oklahoma is going to say, we're right where we were when we started. We just don't have any evidence.
If I know prosecutors, I'm going to say that they don't like when they feel like somebody got away with something, and they certainly don't like when they feel like somebody got away with it twice. And I would not be surprised if they say, you know what, we're willing to die on this hill. We're going to go ahead and bring charges and see if you can pull it off a second time in Oklahoma. I would not be shocked. I just, knowing kind of the prosecutorial mind, that's what I'm guessing might be coming.
That would be a crazy trial, because now are they allowed to bring up the fact that he was charged but found not guilty of his mom's death in that trial? It's sort of like an Inception, which one came first. But if that happens, I would love to follow that trial.
Me too, because then you've got the question, like you just pointed out, of do they get to hear about the mom, even though he was acquitted on that, And it was, really interesting stuff if they do go ahead and decide to do that. Let's take some questions. Hey, Mona says, so many trials are really the battle of whoever is the best attorney. Not a question so much as a comment, but it raises my question of, having watched the trial, do you feel, what was your assessment of the attorneys? Do you feel the prosecution was outgunned, or do you think it was just really came down to the facts?
That's a great point, because here the prosecutor, and his name escapes me right now, but there was just one prosecutor. There was one person on the prosecution table, and it was a one-man show for the entire trial. And that seems rare. And I mean, maybe for a smaller case, misdemeanors, things like that, we see that often. But in a murder trial, especially a high-profile one, you expect to see a team on both sides that are working together. And it was just one. I think there were times that I felt that he was probably trying to do too much. There were times when I felt he should be objecting to things that he just wasn't. The jury instructions, he just let defense get whatever they wanted into the jury instructions, and the judge almost had to make the objection and change things a little bit to make it a little more fair. But for the most part, he was, I would say, phenomenal. He had, with the evidence he had, he presented it well. He spoke well. He questioned witnesses well. He obviously did a better job than I could do, so I can't really fault him for anything. But I do wonder if maybe having a second person who could maybe be the ears while he was working on something else instead of having to do everything at once, it could have been a little bit better.
I feel like we get spoiled a little bit too in this world of watching trials that are on TV, because in these high profile trials, they usually are putting their best people, their best prosecutors, the highest paid defense attorneys. Usually, I know there's exceptions, but I will say that if you have the impression that that is how most attorneys are, you will be very rudely disabused of that if you just walk into any random courtroom, that a lot of attorneys are just really not very good. So, yeah, this, even being able to just kind of straightforward put together a case and put on evidence, I applaud any attorney doing that. I Rescue Dog says, do you think speedy trial hurt the prosecution? This was quick. It did get there. Do you think that was a tactic employed by the defense that kind of put pressure on the prosecution?
I think anytime you have limited evidence, a speedy trial is going to hurt the prosecution. But there was nothing else to get. I mean, what else could you seek? There were no witnesses. It happened basically within closed doors. 2 people were in the room and one of them's dead. I don't think it really hurt the prosecution this time. I think they had sufficient time. The evidence was all there. I don't think it hurt them.
It's funny. The use of speedy trial rights is something that I think is underutilized by defense attorneys, but being a defense attorney and being asked to not waive it and say, I want your trial right away, is also incredibly scary. It's a game of chicken that you're playing, because the defense is usually behind the 8 ball from the beginning, right? By the time the case is filed, they're handing over a stack of documents or CDs or a hard drive or whatever it is, that is the months and months of investigation that they've been doing. And now you got to catch up to it. And if you want your speedy trial, that could be within 2 months, and you got to get up to speed on all of that. But in these instances where they say, let's go for it, I think you're right too. I think sometimes they catch a prosecutor on their heels. I'm not saying that happened here, but I think it has happened. I think famously, if people are really curious about that, where it may have been the biggest example of it, was the O.J. Simpson case. That case, the murders took place and the verdict was later that same year. That's how quick all of that took place. That's unheard of in a double homicide where he's looking at life without parole. That usually takes 5 years to go to trial. And they didn't waive any of that. And I think they put a tremendous pressure on the jury. I mean, on the prosecutors, which may have caused a bunch of errors. I'm thinking about that case a lot because there was a new docu-series out on, I think it was on Netflix or something, that I watched just recently. I can't get enough of these docu-series when they come out on these cases from 30 years ago, because I feel like I'm reliving nostalgia, One last question on this. Where was it here? Okay. Farm Girl said, can you explain probative versus prejudicial? We talked a little bit about it before, but I saw there was a couple of questions on this that I wanted to make sure to get to. Probative means, is there a helpful value to it? In other words, evidence has to move the ball, right? It has to be relevant. It has to be foundationally sound, but it has to also carry some sort of value to it. But much of evidence is also prejudicial, meaning that there's another way the jury could view it that is just dirties up the defendant without actually answering the questions of whether or not the defendant committed the crime. And I feel like I'm doing a horrible job of explaining this, but
that's perfect.
Prejudicial evidence is just, oh, here's a very awful thing that this person did in the past, right? here's a very awful thing about this person. And maybe it has a minimal value as to what they're actually accused of. But in that case, the prejudicial value, the hurtfulness of it that doesn't actually move the ball outweighs the probative, meaning the helpfulness of it. And a judge will oftentimes keep that out. And this is kind of a balancing act that you hear taking place a lot with judges. It's also kind of a fall to argument with prosecutors and defense attorneys, is when they're running out of things to say, they'll just talk about the probative versus prejudicial values. So you'll see that come up quite a bit, where they're like, I don't know what else is going on here, Your Honor. So that's what I'm going to say.
Yeah, there's a misconception out there that all the information would be more helpful to make a decision, and it's not true. First of all, it's not legal. It wouldn't be fair if you were charged with something. It wouldn't be fair to bring your whole life story in to tell the defense, and look at, here's the 5 years ago he was speeding, and they got in a fight with his neighbor and he got sued, and he declared bankruptcy. All that stuff doesn't matter when the question is, did this crime occur? And so they narrow that field with that probative versus prejudicial. And oftentimes we want all the information, right? We want the dirt, we want the scoop, we want to see what the whole picture is, but the jury just doesn't need to see that.
Yeah. One last question, and this is from Pantoufel. Thank you so much for asking the question. And it's a sound question, not even a legal one, but isn't this kid dangerous? I mean, he's now good for 2 dead bodies, and he hasn't even reached the age of being able to drink.
That's the way you put it. It sounds bad. Well, the jury says no. I would say,
what?
I would say that I think he needs some help. There's nobody that can go through those experiences at that age and not have some issues that might need some mental help to work through, some professional help. But our system says he's not.
No, you know what? That's exactly right. We did everything right. He got a fair trial. I respect that verdict as well. I may not agree with it. I may be shocked by it, but you're absolutely right. We should respect it, because I haven't heard in our discussion anything that sounds like it was such a gross miscarriage of the law or justice. But anyhow, shocking case. We'll see what happens with that Oklahoma issue. Can we talk about Megan Boswell just to lighten the mood a little bit?
Oh my goodness, that doesn't get much lighter. That trial did start today. It was day 1, and I have not watched the pre-trial on this one, so I didn't see any of the motions in limine and the arguments that were made there. But day 1 was heavy. Day 1, they just right out of the gate, we started, and within first witness, we were seeing pictures of how they found Evelyn's body in the playhouse that Megan Boswell played in when she grew up, and it was in a trash can.
This kills me. Look at that beautiful little. Can we go back to that, Kaylin? Look at that beautiful little girl.
Yeah, this
just is the kind of stuff that just will haunt me.
Yeah, it was terrible, and it's hard. It's hard to sit through, even just hearing the description, because at one point the camera stopped panning over to the pictures. They couldn't show that, and even just hearing the descriptions of the investigator, who was sort of choking up himself, describing how he found her body and how it was literally discarded, not just in a trash can, but with the kitchen trash, with eggshells and candy wrappers and chewing gum, and how she was in a little purple onesie and wrapped tight in a blanket, but then how aluminum foil had been placed over her face, and not just placed over, but molded to her face, so shaped to the contours, and obviously decomposition had taken place quite severely. There was everything you'd expect with a decomposing body, and him just describing the process of unpacking that on a body bag just outside the playroom. It was tough. It hit me really hard as a parent. I just how can anyone do this to anyone, let alone their child? We don't know, though. Nothing that they presented has talked about the guilt of the death. Everything they've talked about so far in day 1 has gone to the desecration of a corpse, or abuse of a corpse. Some of those later charges that come on when you try to hide the evidence, of a death. And we don't know yet. As far the jury hasn't heard anything about what happened and why they're going for premeditated murder. So we're going to hear all that evidence as we go forward. But it was sure a tough way to start.
Did they talk at all about the cause of death?
Asphyxiation. But that doesn't mean that it happened in the situation where she was found. It could have been, as the defense said, it could have been. They say SIDS. The baby Evelyn was 13 months, so it's just on the outside of that.
The medical examiner cannot determine that the asphyxiation was caused by the wrapping.
We haven't got the medical examiner yet, so they might bring that in. But so far, we haven't heard. Defense is saying it's possible that it's SIDS. It's possible that they were sleeping with the baby in the bed and someone rolled over and it was accidental. It doesn't necessarily mean that the baby was literally suffocated in the garbage, but that is also a possibility. And so we're going to go into all that as things develop.
So just to kind of catch people up on this a little bit, this is out of Sullivan County, Tennessee. Megan Boswell's 18 years old. She's practically a child herself. Her 15-month-old daughter, Evelyn Mae Boswell, that we showed you a picture of there, that beautiful young girl, was reported missing in February of 2020 by a family member. I think it was a grandfather who had not seen her since December of 2019. So we're talking months have gone by before anyone reports this girl missing. And when they do contact her, police do contact Megan, she's got all sorts of different stories. She's at first, it's the girl is with her father. He's apparently on an army base, I think in Louisiana at the time. None of that checks out. Then she says the girl's with her grandmother and the grandmother won't give her back. And then it changes to something where the girl is with the baby, I should say. The baby is with some unknown person but living a better life. So it's this constant, just diabolically insane, changing story and everything. And eventually, do we know yet how it was that they were finally able to discover her on the family property in this shed?
They searched the house or the property initially with a cadaver dog, and it didn't get any hits. But they got a tip to go back and search, and we haven't heard how that developed yet. I'm not sure if the tip was from her then boyfriend, or what the relationship was there. We haven't explored that. But the tip was to go back and look in the shed, and it was in the building next to the shed. That they found her body, but they found discarded, basically all the baby clothes, all the diapers, everything associated with having an infant child, basically just thrown like trash into that shed in that playroom.
They did opening statements, correct?
Yes.
What was the defense's opening? Have they showed their hand, or is it kind of one of those, please wait for us, we're gonna reserve your opinions, we've got more in store, stuff like that?
Yeah, well, defense opening came, right after obviously the prosecution. Before that, they had the reading of the charges, and there are like 20 of them. And then she pled not guilty to all the charges. So defense had to stand up and basically say, yeah, she did some horrible stuff, but none of what she did really fits the charges. And that's why we're saying not guilty. It's all the charges are a little bit different than what actually happened. But she's not guilty of some, and others are just, the desecration of a corpse or abuse of a corpse, however that was termed. It's not quite right. And so they sort of had to dance around the imbalance of them basically admitting that she should have told the police that her daughter was missing. They should, or deceased, and she didn't. And her pleading not guilty to charges that basically mean the same thing. But defense got up and said, it could have been an accident. It could have been SIDS. It could have been, all these other things. It doesn't mean that she killed her baby. And, she might have just been a kid who got in a bad situation where the baby passed away through an accident and then got scared and tried to hide it.
Which, listen, in these types of cases, as disgusting as it is, it's a valid argument to be made sometimes, and unfortunately, it also is something that happens. I mean, sometimes these young mothers in particular, I don't know much about her background, but I'm going to make some awful kind of assumptions here that, you know, probably not the most educated, probably not the most, coming from the most affluent background or something like that, doesn't have resources, whatever you want to call it, and might feel like she's got no options but to just hide a child that died under her care, but not necessarily at her hands. Again, you know, don't come at me like I'm trying to defend her, but it's like, these are the arguments that can be made if they cannot tie forensically or otherwise her to actually causing the death, because she's charged with a bunch of stuff, and a lot of it happens to just do with lying to police. They believe they can prove she knew where the baby was when she was giving all these false stories, but that's tail wagging the dog when it comes to who actually caused the baby's death.
Yeah. Well, they've charged her with premeditated murder, so they've got to have something to convince the jury of that element of the crime, and that's going to be knowledge of, a plan to do it at the time. It can't be an accident and get premeditated murder. But there are some facts in this case that are interesting. Obviously, she had a boyfriend at the time who thought he was the baby's dad, but wasn't. That's a factor. Immediately after Evelyn went missing, she got a new boyfriend and basically adopted what the state said she was living her best life. Just basically stepped away from everything and wanted to, just whitewash the past and move on. So that's definitely not a good look for her as well, especially as all this searching was going on. The family was desperate to find Evelyn, to see Evelyn and find out what was happening.
Let's take a couple of questions here. Our good friend Pantufel, who I'm sure I'm pronouncing that wrong, so I apologize. Please correct me. Says defense opening for Boswell was very weak. They just don't have any good ideas on how to defend the evidence. And that, again, that's not as much as, well, I guess it's a question, but I'm curious. One is that, do you agree with that take that it was weak? And I'm always curious in these cases where the defense has a weak opening, why give it? They don't have to give an opening. You know what I mean? Like, they can either do one of those openings of please just keep an open mind. They can also, in many jurisdictions, do their opening after the prosecution case, which I always think is a very clever strategy. But it's like when you get up there in opening statements and you've got this kind of weak, ham-handed, aw shucks opening statement, it's like you're not really setting the table very well for your jurors.
Yeah, it wasn't the sort of mic dropping opening that makes you hang on every word. It did have a lot of similarities to what I saw in the Collin Griffith trial, where the defense is saying it could have been this, it could have been that, and it is sort of wishy-washy. But the defense's job is to introduce doubt, to make the jury think, that maybe something else happened, and if something else happened, is that a reasonable doubt? So I think they're pursuing that. They obviously have a tough hand. There's some tough facts they're going to have to deal with and work their way around. But it worked for Collin, so even though it seemed sort of weak as far as the presentation goes, it might be resonating with the jury and have their minds thinking, what else could have happened.
A couple of a couple of bizarre things have already occurred in this case, though, right? Because one, we've got an issue with her statement, and I want to talk about that, her interview, and I want to talk about that because I think it's got a very interesting legal question involved in it. But then Ferndale asked the question of who is the material witness that didn't show up and got thrown in jail. I did hear about there was something about the judge issuing a bench warrant for someone.
Yeah, there was a witness that was subpoenaed. We think he's going to be the next witness, like next in order for the state. He was supposed to show up yesterday, and he didn't. I realized they hadn't picked a jury. I think they had subpoenaed people to show up, assuming they'd have a jury picked, and it took longer. He wasn't there. And the judge said, get down here. And he actually released him on bond. I think it's a $500 bond, but he's been ordered to show up every day for court at 9 o'clock and stay there until he's released. So it's a 4-week trial. If he's the last witness to testify in this court, he's going to lose his job. but you don't skip out on court.
No.
We'll find out probably more tomorrow about that witness. And that was a funny moment. We had the judge also stop in the middle of the very beginning of defense's opening statement. One sentence in, stop and kick the jury out, and come down with the wrath from above on the pool photographer whose flash went off.
Oh,
in the
wow.
courtroom.
Oh, wow.
And so he basically said, if that happens again, you're spending 10 days in jail. And then he also chastised the pool videographer and said, if any of the jurors get caught on camera, all of you are going to have a very bad day. So the judge is strict. I like that. A judge that will control his courtroom and not get run over by the whims of,
Yeah, he's a not mess around judge. Yeah. Oh, yes, boss lady, we're going to get to that. Thank you so much for asking too. Just to point out what this is going on here. That's why subpoenas are so important. When you hear about whether or not a person is served with a subpoena, what a subpoena does, and I hate to put on my professor cap, but just to explain to everybody why the judge was able to do this. When a subpoena is served on someone, that is the court now extending jurisdiction over that person. You are now under a court order. So if you don't show up for a subpoena, that is why a judge can say, great, I'm going to issue a bench warrant, which is what I think he did in this case, and they can go pick you up. I mean, I've been in court in cases where we've asked for bench warrants or what we call body attachments, and we asked for it to be a go and get, meaning like, it's not like if they get stopped at a traffic stop, let's lock them up. It means I can look at my sheriff's deputies and say, go find them, and they'll go out and grab them and lock them up and bring them in custody to court. And judges will do that in certain situations and cases and keep somebody locked up. I've had cases where a witness was in custody for the entire time of trial until they testified because the judge was just not sure they were going to cooperate with the whole thing. So I applaud this judge for kind of throwing his muscle around a little bit. But I wanted to talk about the issue of this was very fascinating to me as an attorney, the issue of during the examination. I don't want to mess this up, but I'm trying to set you up and you fill it in better than me. But there was something about during the examination of the detective, he alluded to her making admissions during an interview, and the defense feels now that that's opened up the door to play her entire interview, correct?
Right. The witness on the stand was asked, was there a time that that Megan admitted to Evelyn being deceased? And that was the question. And the witness responded and said, yes, myself and another officer conducted an interrogation, and the witness admitted to that and other things. That was his response. I don't think anything was objected to at the moment, but we went on a break right then. That was basically the last question the prosecutor asked, and he said, turn over the witness to the defense. When we came back, when cameras came back on, defense had basically said, we'd like to play, under the rule of completeness, we'd like to play the entire interview.
Yeah.
And the rule of completeness is set up so that you can't take something out of context. You can't take a little piece of evidence and present it and say, see, we've got the gotcha. And they can say, wait, listen to the whole tape. And that will, and what they're doing here, this is, I think, a brilliant move on the part of the defense, because it is generally a very bad idea to have a defendant take the stand and in their own case. It usually doesn't go well, especially when you have a young defendant. There's no way she can stand up to the
no way
prosecutorial mind of a seasoned prosecutor, and so you don't want that. But what they can do here is say, under the rule of completeness, we are asking to play the entire 2-hour interrogation where she gets to tell her story, because she does. She tells it in this interrogation. The jury sits there, they hear everything, and she cannot be cross-examined. She doesn't have to take the stand. She still maintains her right to remain silent in court, but they get everything out that they want to say. So this would be a massive, massive win for the defense. Even if there are some things in there, I think, that might be problematic, I think this is a huge win. If they get this, there's 100%, there's no way she's taking the stand in the trial. If they don't, she might have to. So that's where we are right now. The judge, as he finished court today, he sent the jury home. He said, I know we're early. You guys are sequestered. They're stuck at the hotel. So go get settled in at the hotel. And once they were gone, he's going back in chambers and he's going to watch that 2-hour interrogation and try to rule, because he's had a lot of case law tossed at him from both sides as to whether, this rule of completeness applies if the witness does get a fair trial, or if this is, he's worried about appeal. He's worried about precedent. He's worried about Tennessee law. And he's going to make the call probably first thing in the morning. And we might be watching 2 hours of video, or we might just move on with cross-examination.
Yeah, this is fascinating. And this is one of those things where it really gets exciting in court when there's like this, everybody's walking on thin ice. They know the obstacles, and then somebody steps in it on accident. Here's the funny thing to me, though. Usually the prosecution wants the defendant's statements in. They're not afraid usually of the interview, even if the interview is sometimes self-serving, because they feel like we can show why it's full of a bunch of lies as well. And the important part is this admission. But it seems like they were trying to avoid that and open the door. And now the defense is very happy to have that happen. And I agree with you. There's no way you're putting this young woman on the stand. Not with her level of sophistication and everything else. They will have a field day with her on cross-examination. So this might be their first opportunity to not only, their only opportunity to not only have her give her side of the story, but for the jurors to even put a personality to the defendant. Like maybe there's some quality about her that comes across in that interview of naivete and, sadness. I don't know. Maybe there's something else on that interview tape that they want to bring in. But I will say that from just trying to analyze this, completeness doesn't necessarily mean everything. Right? It usually means the completeness surrounding a thought. So you can't take one quote out of context and not give the entire context, but that doesn't necessarily mean that you get the entire transcript in of something. And I think that's what the judge is going to have to do, is feel how much of the door was opened up, because the other thing he's battling with here is the prosecution is always allowed to get the defendant's statements in, and the defense is never allowed to get their own client statements in. That's why they have to put their client on the stand. So he knows that they're playing a little bit of a game here. So that'll be an interesting issue. Melinda asked, why were they sequestered? You brought that up. Why are they sequestered in this case?
And this is a high-profile case. It's a lot. I mean, the news media coverage of this is massive. There are many, many large outlets that are covering this. This was a case that was big when they were looking for. I mean, multiple states were involved in the search for Evelyn. It spanned a great area, not just in in Tennessee, and so a lot of people heard about this case, especially in the area, and being able to find a jury that isn't prejudiced, that doesn't have all this preconceived knowledge or experience with the facts of the case. They sort of want to keep them in a bubble and keep them safe. And so they can have a fair trial without them being tampered with in some way from the news stories, which there are every night. I mean, everyone's doing recaps, everyone's talking about what happened and what's coming up and what do we expect, and the jury just can't have that, even in a small bit, because that could definitely influence how they vote.
I feel like we're hearing about sequestration like this much more often, and I don't know if that's just I'm paying attention more and it's just anecdotally seems to be happening to me, or I wonder if it is a side effect of more coverage of cases and more media availability and more people available to follow these things, and that not just being in the form of newspapers. Years ago you could just tell jurors, don't read the paper, don't turn on your TV at night, but now your phone, everywhere you turn, your phone is even sending you push notifications. It's like you can't avoid it. And I wonder if they feel like in this modern age, that's what they need to do in these cases.
Yeah, I think you're right. I think the more exposure and the more media works its way into a court proceeding, the higher the risk of a jury being exposed to it. It's going to be on TV, it's going to be on the newspaper, it's going to be on the radio, and it's just more chances of the jury seeing that. So I think on cases like this, especially where it's difficult, I think they had 1,200 jurors, a pool of 1,200 to seat, to find 12. So 1 out of 100 is what they were, hoping to get, and they were able to.
Yeah.
They don't want to go through that expense. It is massive. The expense that's involved in a retrial. If there's a mistrial for some reason, if there's juror misconduct or the pool gets tainted for some reason, Nobody wants to put everyone through, not just the court system, the financial cost, but think of the victims, the people that have to testify, the experts, the time, the money, the weight on the families of the victims of being dragged through this a second time. They want it to get it right the first time, and they put that burden on the jury, and it is a burden. I mean,
it's a big burden. I'm saying
4 weeks.
If you think you have enough trouble getting people to show up and be a part of jury service to begin with, start telling them they're going to miss not only 4 weeks, but miss their family life and everything else for 4 weeks. It's going to be tough. Last question on this, Scott. The boss lady asks, Evelyn's law, or it doesn't ask as much as points out, and thank you for the contribution, about this new law that was passed. And I thought this was fascinating and wanted to get your take on it. It's called Evelyn's Law, and it seeks to increase penalties for parents or guardians who do not report their children missing within 48 hours. Failure to report while demonstrating a reckless disregard for the safety of a minor is a Class A misdemeanor, which can carry a sentence up to nearly a year in jail and a $2,500 fine, or both. I love it that they're doing it. I think it's fantastic. I think it's a law that should be on the books anywhere, but it also, to me, it's like that's kind of a crime even without that. I mean, if you're not reporting your child missing after 48 hours, I think that would fall squarely into child neglect to begin with. But
yeah,
I mean, at least one silver lining of this whole nightmare of a story is that there's now the legislatures are taking this more seriously about reporting children missing.
Yeah, they did. This was a unanimous vote. This bill passed with unanimous support, as this type of bill typically does, and it was directly in response to this, because everyone looks at the situation and say this shouldn't happen again, and what can we do to fix it? Will it fix it? I'm not a big believer that one more law will stop a criminal from doing a crime.
Right. If you've already, this is so horrible, but I'm going to say it. If you've already taken the life of your child, you're probably not worried about the misdemeanor of not reporting it at that point, right?
Yeah, it's sad. I hope that what it does, though, is in everyone else's lives in the community, they can look at that and be more alert and be more aware.
Yes.
And that's why I'm watching the case, because it's brutal. I mean, it tears at the heart in a major way. But I think even I need to be more aware of people around me. These situations don't just happen, one off in Tennessee and once up in Idaho with the Vallows. Sadly, they're happening in every state. Yeah. And there are kids that are in this situation or close to it right now, and they're in our neighborhoods. I think it's important that we listen to this case, and not just to see that there's justice done for Evelyn, but that we can look at this and say, what can I do to make sure that it doesn't happen in my family, or doesn't happen in my neighborhood or my community? And even if it's just paying a little closer attention to somebody who's struggling with parenthood, and seeing, help step in and say, hey, can we help? What can we do?
I couldn't agree with you more. And I think that's a perfect way to end our conversation on this. Sir, you are a true gentleman, and I appreciate you for coming on tonight, and I appreciate you sharing all your thoughts, and I appreciate you bringing along with you and our army of supporters who are in the chat, and has made this evening so fun for all of us. It's so nice to see so many new names, and that I haven't seen the chat ticker move this quickly in a very long time, so that was very encouraging. So hello to all the new recovery addict people. Scott, I would say tell us where we can find you, but I imagine everybody already knows where to find you on YouTube. But if you have not subscribed to Scott's channel already, do yourself a favor. If you're interested in following cases, he provides an experience that is really unparalleled by other people on YouTube. And if you would like to know everything about Scott, including the fact that he had top secret clearance at one point, and his entire background, we sat down for a really great interview in our conversation series. That's going to be coming up on Monday, February 10th at 5 p.m. Pacific, 8 p.m. Eastern. It's going live. We'll do a kind of countdown show for the first half hour before that, but I would love to see all the new folks there to watch that and join us in the chat. And I'm hoping, Scott, if you can carve out some time to join us in the chat as well.
I'd love to. Josh, I've really enjoyed this. Thank you very much. We'll have to do this again soon.
Absolutely. What's that?
We'll have to do this again soon.
Oh, absolutely. I'm gonna bug you. I'm gonna hold you to that.
Sounds good.
All right, my friend. Take care.
Bye.
What a great guy. What a just an awesome human being. And I imagine all of you already know, but if you don't know, please do go check out his channel, because he has just so many tech things that he's doing that are so unique, where first of all, he'll show you his own point of view and all the screens that he's got set up and the entire tech panel that he's got set up of how he's able to tune into all these different trials throughout the country. And what I love that he does too is if there's like downtime in a trial, they do this thing called court hopping, where it's not even cases that you are making a bunch of headlines, but there is a bunch of different courthouses throughout the country that are live streaming at all times. And he'll just check in and see what they got going on. What's going on in this misdemeanor drug arraignment court in, Tallahassee, and see what they're up to, or shoot over to some other courtroom that he really likes the judge. And I think it just gives such a unique experience as to all the different trials beyond just the kind of headline making cases that we're used to watching. So I'm so grateful again for him being on. I'm so grateful for everybody who joined us this evening to have that discussion with Scott. And again, check out that interview that we did with him, because it was really, really fun. All right, Kaylin, I think it's time for our poll. I think we got time to at least get to our winner of the poll. We got to come up with like a drum roll sound effect for when you do this, Kaylin. Oh, here we go. Jennifer Crumbley, 45%. Interesting. I'm glad you guys picked that. I'm glad you picked that, because it was the one to me that was the most interesting, because I think the government did a boo-boo. I think they messed up. I think they messed up, and this is kind of a repeated refrain that I have on this channel. Having been a prosecutor, I feel like I can lay into them when they do wrong, and I feel like they did wrong in this case. And they usually do wrong when they just don't turn stuff over. I mean, here's just a lesson. If I can get on my soapbox for one hot second. Turning stuff over doesn't mean it comes out in trial. Okay? There's a wide difference between what is turned over in discovery and what a judge allows in for trial. And when prosecutors start making the decision of, I don't think this is either important to my case, therefore I'm not going to turn it over. I don't think it's important to the defense case, therefore I'm not going to turn it over. Or for some reason, and this is usually the worst, I feel, and I'm already making the decision that this is problematic and not helpful, and therefore I'm not going to turn it over. That's always where they get themselves in trouble. Prosecutors are, part of their job is being the stewards of the evidence, because they get everything. Everything is handed to them by the investigators, and then it's up to them to hand it over to the defense. And there's only a few rare instances where they shouldn't be turning stuff over. And that usually has to do with protecting the identity of other witnesses. If you've got a horrible, thank you so much. Oh, Scott, you're fantastic. Thank you so much for that. Those memberships. If you've got a horrible gang case, I did a lot of gang cases. And sometimes there are witnesses whose identities we're trying to protect. And first of all, we're going to disclose the statements that they've made. We will even make them available to the defense for interview, but we're not going to disclose where that person was when that interview took place. Sometimes we don't want to do anything to put that person in jeopardy. Those are an example of rare instances where you might not turn something over. But for the most part, I took the stack handed to me from the detectives. I made a copy of it and I handed that same stack to the defense, because I know at the end of the day, they're not going to get all of that in. If I feel like it's irrelevant, I'm going to make a motion with the judge and get it kicked out. But you don't make the decision. You don't put your case on the line and your bar card on the line and start making a decision about what you're going to turn over or not. I was, I guess, much more fearful of discovery violations than I've seen some prosecutors be. And that's what happened in this case. So this is the case. It was already a case that was a little controversial because you're, for the first time in the history of criminal law, we are charging parents with a crime for a crime that was committed by their child, an independent actor here. Okay. Yes, Ethan Crumbley was their child. Yes, they had certain duties to supervise him properly. Yes, they should have realized that he needed help. All of those things are true. But he took it upon himself to go get that gun. He took it upon himself to hide that in a backpack and walk to his high school that day. He took it upon himself to take it out and start firing it at students. All things that his parents did not have control over. Yet, the prosecutors went after the parents and found them criminally liable, and a jury did as well. And jury found them guilty of manslaughter, okay? Involuntary manslaughter, but manslaughter nonetheless. In other words, this was not a child neglect case that was directly holding them responsible for the deaths of those individuals. I understand the frustration with school shootings. I applaud efforts to do something to stop this. I am still bothered by if this was one step too far in this case, but that's kind of a rant for another day. Putting all of that aside, what took place in this case was the same judge, Judge Cheryl Matthews, who sentenced Jennifer Crumbley, now has the issue before her of whether or not the prosecution screwed up by not turning over the proffer agreements that took place between Oxford High School counselor Sean Hopkins and former Dean of Students Nick Ejak. Okay. A proffer agreement is sometimes referred to as queen for a day. What a proffer agreement is I want to speak with someone as a prosecutor. I know that person doesn't have to speak with me. In order to make them feel comfortable to speak with me, I'm going to essentially give them what's called use immunity. I am going to tell them that they can tell me anything, and I will only use that to glean information as it's helpful to my case. I will not use what they're telling me against them. Now, that doesn't have to do with immunity that may be provided if they testify. That doesn't have to do with promises that may be made if they testify. It just has to do with me gaining information. The federal government does this all the time. In fact, the U.S. Attorney's Office this is almost the entire way in which they prosecute all their cases. They find one jerk in an overall huge conspiracy, and they get that guy to proffer, and he starts diming out everybody else. And then they go around to each one of those people and they offer them proffer agreements, and they dime out everybody else until they've all centered in on the guy at the center of it. And that's the mob boss. That's how the U.S. Attorney's Office basically does their investigations. So in this case here, it sounds like the government wanted to speak to this school counselor, Sean Hopkins, and the former dean, Nick Ejak, and get them to tell them what they knew about this young man, everything else leading up to that. And they gave them a proffer to do that. They didn't turn that agreement over to the defense, and these two people testified. Why is that a problem? Because the defense, not only should they just get it in discovery for the reasons we talked about, but they need to know, are there any potential biases under which this person is testifying? Now, you could say, well, that person's just testifying honestly to be honest. But shouldn't the jurors also be made known of the idea that the only reason this person agreed to cooperate and speak with the prosecution in the first place is they were given a proffer? I think so. And the judge, it sounds like, thinks so as well. The judge's quote, amongst other things, was that she was very, very concerned about the possibility of a discovery violation here. So it sounds like the judge is going to find that there was a discovery violation in not turning over these proffer agreements. That's step number one. Step number two is, how do you remedy it? What do you do now? okay, this discovery violation took place. How do you fix that? Well, the defense is saying, give her an acquittal. In other words, throw out the conviction altogether and say that that so tainted the case that she shouldn't have a conviction. Judge is not going to do that. Judge already indicated, I don't see that happening. But I'll point out again, this is the same judge that sentenced her, the same judge presiding over the case, is now feeling probably equally bamboozled by this, that she wasn't made aware that there was this proffer agreement, and the prosecution didn't make any aware. The prosecution, for their part, is kind of explaining this as a real splitting of hairs in that, listen, they weren't really given immunity. They didn't testify under any kind of conditions of immunity. Therefore, there wasn't any bias. I don't buy it. It is a use immunity having been provided to them for them to even speak to the police in the first place. That is something that should be turned over. And regardless if the judge was going to, again, to my point, the judge may decide that this is something that the jury doesn't need to know at trial, but you need to turn it over in discovery and let the judge hash that out later on. And the judge was never given that opportunity, and the defense was never given the opportunity to even make those arguments, because the prosecution made the decision for everyone by not turning it over. Okay, so they're probably not going to get a acquittal out of this whole thing, but will they get a new trial? And that's a very interesting question. And that's a much more difficult question. And that's a much more difficult argument for the defense, because what they're going to have to show is that this not only was a problem, but it was such a huge problem that it likely impacted the juror's decision. And so were these two witnesses so pivotal, so important to the prosecution's case that you basically have to say, had they not testified, would the jury have found differently? And that's probably a much more uphill battle. But the judge is saying I believe the judge, first of all, hasn't made any decision, but I believe the judge is going to say there was a discovery violation here. Now, just what do we do with it? Again, a really interesting issue. You know what? We got time to do one more quick one. Did we have a runner-up, Kaylin? I kind of secretly want to get into Lori Vallow. Should we just talk about Lori Vallow, just because I think it's so kind of silly what she did here? Yeah, let's just do it. Go for Vallow. Crystal DeSara says, go for Vallow. I like that. Thank you. With your permission, I'm going to go ahead and go for Vallow. All right. Here's what she filed. This is Lori, if you don't know what she looks like. Lori, just to catch everybody else up, if you've been living under that true crime rock, she was convicted in Idaho of conspiring in the murders of her two children, Tylee Ryan and JJ Vallow. It's an awful, awful case. Scott alluded to this as one of those cases that just continues to haunt us in the community as to how horrific it was. She was also convicted in Idaho of conspiring to kill her new husband, Chad Daybell's current wife, Tammy Daybell. Now she's on trial, having been accused of conspiracy in the murder of her prior husband, Charles Vallow, and the attempted murder of Brandon Boudreaux, who was, I think, her niece's, it's like her nephew-in-law or something. You guys will correct me, but it was somehow related. It all comes back to the same sort of theory by the defense and by the prosecution, rather, of either money or bizarre fringe religious beliefs being involved in the whole thing. These two shootings took place within months of each other, but they're being tried separately, which is bizarre to me. I think they should be wrapped up in the same case, but for whatever reason, they're being tried separately. But that's really not what we're talking about tonight, because what Lori did, she's obviously either suffering from severe mental issues or just really in the deep end into these religious beliefs that she has. We even saw that in her behavior in the trial where her own children's lives were taken. She just doesn't seem to be distraught by that at all. And now, oh, it's her niece's ex-husband. So her ex-nephew-in-law. Got it. Okay. But what's happening in Arizona is that first they had to decide whether or not she is competent to stand trial, which we know is a separate hurdle than insanity. It is a lower hurdle, but it basically just says, does she know what's going on around her? Does she know who the judge is and what his role is? Does she know who the jurors are and what their role is? Does she know what she's charged with? Does she know what she's looking at? Does she know the consequences? Those are fairly low standards. She's been found competent. And then separate and above and apart from that, she's also been allowed by the judge to represent herself. So she was able to give a willful, conscientious, and knowing waiver of her own right to counsel. And she's now being allowed to represent herself, which is, another step in a direction towards the madness of this entire case. But now you've got this person who's a wild outlier of an individual to begin with, now going to be representing themselves. And what is that going to lead to? Well, it's already led to a bunch of bizarre discovery requests, in that she wants to know all the reasons why she was extradited, which have nothing to do with the case. But the latest was she filed this motion here. This is, and it's not very long at all, but somehow she's got access to, I don't know, I guess a computer, or somehow she was able to put this together. It's defendant's objections to Court TV's media request for trial. I'm just going to read you this entire thing because it's only a few sentences long. It says, the defense objects to Court TV's request in its entirety because of the bias they have already created in the community. Namely, Lori Daybell and her husband, Chad Daybell, are the commercial for Court TV. That commercial runs constantly throughout the day and has falsely characterized, libeled, and slandered the defendants. Apparently, she has access to Court TV while she's in custody. Court TV should be ashamed of its very nature and its request, since its sole objective is not to bring people real news or facts, but instead its objective is to entertain the public with its very true life tragedies that happen in real people's lives. She actually have some point there a little bit. The defense objects to Court TV being allowed by this court to participate in this judicial process, including their specific request to appear at trial, live stream the proceedings on the web, and distribute the live feed. Okay, a couple of bizarre things to point out. One, she's only coming after Court TV, which is funny. It's not like she's saying no cameras. She's just saying, I don't want Court TV in there. So I don't know if this is going to be interpreted as an overall request that there be no cameras, or if she cannot live her life without all the intention and she actually wants cameras, she just doesn't like Court TV, because the way it's spelled out and the way I read it, Emily Flotilla is correct. Just not Court TV. She's got a problem with Court TV. She feels the Court TV is exploitive and profiting off of her likeness and off of the drama that they've created and the bias that they've created, the falsely characterized libel and slander against her. And therefore, she doesn't feel Court TV should be allowed to be in court, which brings up a lot of interesting kind of First Amendment issues. Can you say, I've got no problem with, she doesn't hate law and crime, says Melinda. Yeah, that's the point, is can she say that I've got no problem with the broadcasting of this? I've got no problem with the media. I've got no problem with their First Amendment right to observe these proceedings. I've just got a problem with this one particular outlet. And I feel that they are harming the fairness of my case, which is a genuine issue, which is an issue a judge should consider if they feel, we see this all the time, right? We just talked about judges sequestering jurors because they're concerned about how is the media attention affecting a case. We've seen cases where judges shut it down completely. So the idea of raising concerns about media coverage on a case are not invented by Lori Vallow. But she's not really saying I've got a problem with the coverage. I've just got a problem with one outlet and how one outlet alone is affecting my ability to have a fair trial. which is interesting. Let's say, just for a moment, she's got a point. Let's say she's able to actually point to something where she feels like Court TV has been particularly exploitive in the way that they've covered it, that they've not covered it just objectively and presenting the news, but that they're turning it into something that they feel that they're making a profit off of, and not acting entirely as a media outlet, but more as a tabloid or something. And that is affecting the fairness of her case. How does the judge order one media outlet not to cover news? In other words, if they're still allowing court cameras in the courtroom, Recovery Addict is going to be covering it, and Law and Crime is going to be covering it, and everybody else might be streaming it. How do you say that then Court TV is the only outlet or news media not allowed to discuss this or have a live feed of the whole thing? It's just a interesting kind of question, and maybe more, maybe more just a fun discussion than will actually happen, because I think what's going to happen at the end of the day is the judge is going to say, are you objecting to cameras in the courtroom? She's going to say no, and he's going to say, well, then I'm denying this motion because I'm not going to single out who covers it and who doesn't, and I'm going to admonish all outlets that cover this and use the same pool camera. By the way, it's not like Court TV's cameras are in there. It's usually a pool camera that everybody's taking feeds off of. I'm going to instruct them to cover it in an objective manner. And everybody else, if they're editorializing on it, I can't do anything about that, because the judge is not going to stop the First Amendment right of other people, myself included, Recovery Addict, whoever else covers it, from editorializing with their thoughts on how it was, the case is playing out. Anyhow, kind of funny, kind of interesting. All right, guys. You're all fantastic. I would love that so many people were here tonight. I always take a moment to thank the new members that we've had over the week. So I want to say a special thank you to Emily Flotilla, Mad World, Ruan, Lamarine, Susan D, Calypsis Vixen, True Crime Addict, Dr. Anya Renarzofwaska. Oh, I'm so sorry. The Goodmans, Mr. C, Lori Marie, Tracy K, Kathy, Rosie's Overruled, Gloria S, SDK, Serenity RPH, Miss Kitty, Marsha Bishop, Peggy Breidenbach, and Joanne. Sorry if I butchered your names. Thank you guys again. Tracy, thank you for that. Sarah Boone 2.0, you're absolutely right. Tracy again. YSL Pros had to take a Brady class during trial. Yeah, that's true. They had some problems in that case. Thank you, Rowena, pardon me. Thank you, Bug Dugger. Thank you, everybody that I failed to miss tonight. Emily again. Oh, wow, 42 years sober. Go back to that one. Congratulations, Emily. That's an incredible accomplishment. Way to go. 42 years sober today. That's well worth sharing and celebrating. Good for you. Joy W for the super sticker. Ricky Watson for becoming a member. So appreciative of all the new members. Dr. Bullbutter that we've seen this evening. Thank you guys. Carol Engel. Who else do we got? Steel and Stitches. God, we're again, I think this is all Scott, and he's fantastic for bringing the love this evening, for all the new members that we were able to join our crew. Pantoufel again. Thank you. Love finding new channels. I appreciate you saying that. If you guys are interested in our membership, you know what I'm going to tell you. I'm going to show you where to go so that you can find out about joining our membership program, which we are very proud of. The things that we do here to make it an experience that you guys feel is worth being a part of. You just go to thecourtroomconfidential.com and click on this button here, become a member. Become a member. This video will pop up. This link will pop up, and you just click on that, and you can join our Courtroom Confidential crew. So I hope that you guys feel like that might be something you want to be part of, like Bug Dugger has done. If you did not see it, thank you again, DSN. That's very nice of you. If you did not see it, On Wednesday, we had our latest conversation with Scott Reich from Crime Talk. Please check that out. Tomorrow, oh, this is fun. Tomorrow, I'm going to be a guest on Reporting Live from My Sofa, which is with Paul. He's fantastic. We've had him as a guest on the show, or rather done an interview with him. So he's invited me to come on his show. That will be tomorrow. We'll stay tuned. We'll send you guys links of where to check that out. Friday, we have our weekly roundup. And then, like I said, for all you Recovery Addict crew members out there, tune in next Monday. Courtroom Confidential, newest conversation series episode with Scott, premiering Monday, February 10th at 5 p.m. Pacific, 8 p.m. Eastern. Would love to see all of you new folks there. But thank you again for everybody being here tonight. You're all fantastic. And I hope you have a wonderful rest of your evening and a wonderful rest of your week. And I will talk to you all soon. Take care.